we haven't talked about Paul Boyne in a little while. Paul Boyne, it's like well over 2 years since he was arrested, about 2 years since he was in Connecticut. He's being charged for writing mean blog posts. It's a little more than mean. He's talking about shooting 50 cals in judges' heads, and they claimed it was, I don't know what they claimed. It's all BS. There's plenty of case law from the U.S. Supreme Court and other courts less important than the U.S. Supreme Court. This stuff is allowed. Mr. Watts said, if they give me a gun, the first person I'm going to shoot is LBJ. If that's allowed, then Paul's saying someone should put a 50 cal into a judge's head should be allowed as well. And look, if that's not allowed, how come me repeating it is allowed? So give me a flip and break. Look, on Paul's website, he had a section where he talked about case law that allowed him to say the things he said. No one believes something's a true threat.
Still up there. Still up there.
Right. Yeah. Nobody believes it's an actual threat if it comes along with case law explaining why it's not a true threat. Give me an effing break. But what the latest are two interesting, well, one order and one motion. This is New Hampshire State Attorney Jack Doyle. That is the equivalent of New Haven. I'm sorry, New Hampshire, New Haven, which is I assume a county in
that's where Yale University is. New Haven,
right.
Connecticut.
He's the equivalent of the DA. It's his office. I don't think he himself is prosecuting it, but he might be.
Yes, he is.
He is. This is how serious this is how serious he takes crime. The guy elected is actually prosecuting Paul. So what he wants to do is not let Paul see his discovery. Am I right?
Yeah, he made this motion. It's 2 pages long, Mike. So
right. Well, hold on. So he doesn't want Paul to see his discovery, but he makes a good argument. The state also included a discovery disclosure. Oh, not there. Hold on one second. Okay, here we go. However, on or about May 14th, criminal discovery that was not authorized by the state, or more importantly, a court, to leave the custody of a prior defense counsel or the defendant made its way on the internet, specifically onto the family court circus. See? Quote, Boyne strikes back as Jack on crack or just a plain whack. He's talking about Jack Doyle. Obviously, making fun of Jack Doyle is not allowed. Last accessed August 22nd, 2025. Well, here's the key. In addition to the default requirements of practice book here, in light of the fact that the criminal discovery in the above caption is made its way on the internet, it is appropriate for the court to deny possession of the physical criminal discovery to the defendant. He's saying that the practice book was violated. Doesn't he have a point? You can't violate the practice book. What are you talking about?
Yes, so because
Paul shouldn't have discoveries. Somebody violated the practice book.
It's doing what Paul Boyne says, that the First Amendment doesn't operate in the state of Connecticut, right? In other places that have a functional First Amendment, there's a right to free speech, a right to the press, a right to speak with the press, and a right for members of the press to talk to other members of the press.
But is this guy right that if you receive discovery, you can't release it? What the hell is he talking about? I don't believe that.
Michael, you need to have a national security defendant to even start to think about this. Like you're giving plans to nuclear reactors or something like this. It's so out of control that has got to this. But the bigger part about this is his counsel, his appointed defense counsel, and we asked him a whole bunch of questions, and that's the biggest issue that we have here. Now, Paul, we know what Paul says. Paul says that that everybody's out to get him, and the Jews are.
This is his counsel, Todd Bussert. Go ahead.
Yeah. Todd is actually a very good attorney. He's in private practice before, and Paul's belief is that Todd got talked to by the Jews. If you ask Paul, that's what he'll tell you, that the Jews are in charge. The quote-unquote judiciary is in charge of Connecticut, and they're trying to protect Joette Katz in this case, who was running like an all Nazi kill squad. And Paul was
Joette Katz was formerly on the Connecticut Supreme Court. She was also formerly the head of I don't think they call it CPS, whatever they call it in Connecticut. She's now in private practice, which is peculiar to say the least. However, in a piece of discovery, it says talk to Katz only by the Connecticut State Trooper in charge of the investigation, Sam McCord, wrote that in notes. So that led some people, Paul namely, to believe that Ms. Katz was running an off-the-books investigation. We would know more if Mr. Bussert could depose Ms. Katz, but Mr. Bussert doesn't think deposing Ms. Katz or asking too many questions about speak to Katz only is a good idea. God forbid, he might zealously represent his client and make a few people mad. Maybe Mr. Bussard needs to watch My Cousin Vinny a few times so he could learn what a proper defense counsel should be like. He
Quick
needs to
question.
be a little more Vincent LaGuardia Gambino, I think.
Vincent LaGuardia Gambini. There you go.
Gambini,
So,
I'm sorry.
Michael, I have a quick question for you, and then we'll get into this email. But the quick question I have is this. If you were married, right, and you live across the street from the Smiths, and your wife found a piece of paper in your handwriting on your dresser that said, Jane Smith, Motel Friday. Do you think your wife would have reason to think that something was happening?
Yeah, she might. In the same way, you, if you're Paul Boyne, might think something is amiss if the head of the investigations, Sam McCord, who has a crush on me. She has a crush on me because she talks about me a lot. That's why I think she has a crush on me. But anyway, you would think something is amiss if she says, I think you've got it somewhere here.
Yeah, put it
Here
there,
it is. Speak to cats only. Cats speak to only. I'm sorry. Cats speak to only. You would think something is amiss if you were Paul Boyne. He's been able to find out nothing more about this, but this is hanging over the truck. Look, this on its own could, well, probably not on its own, but this could be the start of a great motion if you did some investigative work and subpoenaed some.
You got to talk to cats at this point. It's in the name of the discovery. Talk to cats.
Right.
See what you got. Or even if the judge were to put something in a letter that says, well, everything that Paul Boyne says is bullshit. At least they'd have something like that to use, but they're not going to, because that could put her into a big load of poo-poo. Now go back up to the Todd Boosard stuff. These are some of the questions we asked Boosard. And right now, go ahead.
Given these concerns, we would like to ask: 1, opposition. Will the Office of the Public Defender be formally opposing the motion in full or only in part? Now, after you asked these questions, we got the answer because Mr. Bussard did file the motion and he did oppose it in part. He does think Paul should have the right to physically have discovery. He doesn't think that opposition needs to be to releasing it to the public. What do you think of the motion that the response that Bussard filed?
I think you just hang him up at this point. If he thinks that that's in any way, shape, or form something that's constitutionally, viable, I think he's lost it. He's lost his way.
I initially thought it was good, but then I didn't see that he didn't oppose the protective order that Jack has. Paul doesn't make it easy for people to represent him. But
read that question though, because that goes to the constitutional points.
All right, so let's keep going. Some speculate that you intend to oppose the request to prohibit Mr. Boyne from possessing appropriately redacted discovery material while not opposing restriction on online posting. That's exactly what happened. Can you clarify the scope of your opposition? He clarified by actually filing the motion. What does, quote, appropriate redacted mean? By implication, does it also mean that Mr. Boyne's press activity and contacts are constitutionally inappropriate from the perspective of the Office of the Connecticut Public Defender? Paul is a public defender, but this guy's like the head of the complex litigations unit. He should not be a hack. Is the Office of the Connecticut Public Defender being, quote, strong-armed by the Jews, as Mr. Boyne alleged? I doubt it. Number 2, constitutional grounds. Do you plan to raise constitutional objections under the First, Fifth, Sixth Amendment, in addition to Connecticut practice book provisions citing the state's filing? Press clause concerns. Does your office recognize Mr. Boyne's right as both a criminal defendant and a journalist blogger to publish matters of public record? I want to go back to Jack Doyle's, and I want to scrutinize this. So he says, however, on or about May 14th, criminal discovery that was not authorized by the state, or more importantly, a court, to leave the custody of prior defense counsel or defendant. The implication here is that Paul needs someone's permission to publish something.
That's a lie. That's a lie, Mike. Go down. Go to the picture of Judge Brown, because Judge Brown actually, right there, go the cherry on top. Read that. Go back up. That paragraph. The cherry on top.
The cherry on top is that the standing order in place signed by Judge Peter Brown, who is presiding over the case, allows Boyne full access to the discovery material to aid in his defense. Evidently, Doyle delivered a new batch of discovery documents to Boyne's lawyers on August 1. Boyne says he hasn't seen them. And keep in mind that Paul recently, in the last couple of months, discovered that I think 4 or 5 years ago, the Connecticut judicial marshals, those are the people that have security for the Connecticut courts, did an
95.
85-page report on Paul Boyne. So it's possible that report is sitting in the hands of his attorney, Todd Bussard, and he doesn't want to share it with him. Whatever it is, he's got to share it with his clients. And how is it not malpractice not share it with your client? You don't know how your clients can be able to help.
Yeah, now go back to the next paragraph. Boyne says
Doyle is trying to tie the disclosures up and interfere with his relationship with his counsel, as well as any help he might provide.
So you're not allowing him to assist his counsel. You have a right to effective assistance of counsel. Doyle's trying to tie that up, and he looks like he's trying to cover up something in there. It could be that report. It could be Joe Katz's involvement. It could be something else. It could be Ned Lamont himself could be liable here for something. He might be protecting who knows what interests in Connecticut. So this is totally within the crosshairs of why we have a First Amendment. This is totally in there.
I agree. There's a lot wrong with what we just recently discovered. There's way more wrong with the case itself. This should have never been brought, but as I wrote in an article that is behind the paywall, he's like a martyr, Paul is, which is sad because he's also definitely a racist, a sexist in some ways, a anti-Semite, a homophobe. If you had just let him be, that's what he would have been.
He gets the bingo card, Michael.
Right, but you went after him for no reason. He really wasn't. The influence that you think he has is created by you, the state of Connecticut. You gave him all of this power. But so anyway, we'll stay on it. But the other point that I wanted to make is, I think it was July of 2023, Paul was first arrested. It took a few months for him to be extradited. Now, so we're talking August, September of 2023, he was extradited. He got new lawyers. I think it was December of 2024. We're into September. And Brown had some thoughts about holding a trial this month. I don't think that's going to happen. Here's something I learned about Idaho. In Idaho, the right to a speedy trial requires that a criminal defendant be brought to trial within 6 months of entering a plea of not guilty. So that's about 2 years ago. Even if you argue, well, it just got new defense.
Connecticut has one too, and the Sixth Amendment has one too.
Right. So, but they specify that it's 6 months. So Bussard's been on the case for more than 9 months. How come he hasn't been able to? You should be ready.
Well, I don't think that they filed a motion for speedy trial yet, or they have invoked speedy trial at this point.
Right. No, they're all letting him languish. And also, the Hartford Courant, which does some stories here and there, isn't pressing the issue that he should be tried. No one else.
Current on that. They were on the emails. They know everything that's going on.
Right. No. Yeah, that's Ed Mahoney. He's a hack. He has a lot that he could write that he doesn't write.
He's on a media board with Joe Katz. There's like this special.
Right. Yeah. He's on the.
I talk about it later, Michael. Journalistic treason. This is what
right.
This is.
Okay. We'll have more on that.